Good afternoon. I'm just going to wait a few seconds where I can see some of our participants are just coming in to the webinar. So I'll give it a few more seconds and then I'll run through with a very brief introduction. Okay, good afternoon and welcome to Drystone Chambers. My name is Russell Burton Lawrence and I'm the Chambers Administrator. Chambers is absolutely delighted to host this webinar today, focusing firstly on community protection notices and criminal behaviour orders, and then secondly, closure notices and closure orders. Today's presenters are Kenniesha Stevens and Richard Davies, both members of Chambers. And briefly, by way of introduction, Kenniesha Stevens is a criminal practitioner who also specialises in regulatory crime. She has experience across the full range of regulatory crimes, including trading standards, food safety, environmental, fraud and restraint and confiscation proceedings. Prior to her career at the bar, Kenniesha was employed by the London Borough of Camden in the prosecution team, responsible for legal actions related to antisocial behaviour cases. Kenniesha was also a grade 2 prosecutor for the CPS in general crime and fraud panel cases. Richard Davies is a criminal and regulatory crime practitioner with over 10 years of experience. He defends in Crown Court trials as a lead junior and as junior counsel alone. In addition, he prosecutes matters for local authorities in cases relating to topics such as housing enforcement, environmental crime, and trademark offences. As predominantly a defence practitioner, Richard brings valuable experience from the other side of the trial process when presenting on behalf of the local authority. So as to the structure of today's talks, Kenniesha is going to start things off and she'll be focusing on community protection notices and criminal behaviour orders. And will then hand over to Richard, who will consider closure notices and closure orders. Each talk should last approximately 30 minutes, and please feel free to submit any questions as we go along in the via the Q&A button. At the end of both presentations, Kenniesha and Richard will endeavour to answer as many questions as possible. When exiting the webinar, an anonymous feedback form will appear, and we should be most grateful if you could complete this for us. The webinar is being recorded, and both the recording and the presentations will be made available to you in due course. Okay, so that's the introductions. I'm now going to hand you over to Kenniesha Stevens.
Thank you, Russell. Hi, my name is Kenniesha Stevens, and I will be talking today about community protection notices and criminal behaviour orders. Starting firstly with the law, CPNs, criminal protection notices, are governed by sections 43 to 46 of the Antisocial Behaviour, Crime and Policing Act 2014, and that's part 4 of the Act. And CBOs are governed by Part 2 of the Act. And so firstly, dealing with what is a CPN, or what are CPNs? CPNs are designed to stop a person aged 16 or over, a business or organization committing antisocial behavior, which spoils the community's quality of life. They cover a failure to act as well as positive acts, and that's section 57 of the 2014 Act. They are intended to replace litter clearing notices, defacement removal notices, street litter control notices. They are not intended to replace the current statutory regime under the Environmental Protection Act 1990. And although there is nothing to stop authorized persons from using CPNs alongside the statutory nuisance regime, for example, whilst investigating whether something constitutes a statutory nuisance, guidance suggests that the issuing body may wish to consider whether issuing a CPN is necessary given the powers afforded to the local authority under the Environmental Protection Act 1990. When and who can issue a CPN? So examples of when a CPN may be issued: when a dog is constantly escaping through a broken fence, the owner could be issued a CPN requiring that the fence be fixed to avoid further escape. To a local shop, supermarket who are allowing litter to be deposited outside the property, and to prevent antisocial behavior such as regularly playing loud music in a public area. And who can issue a CPN? That can be found in section 43, subsection 1 and 53 of the 2014 Act. So those authorized to issue CPNs or an FPN are a police constable, a local authority for the area where the ASB conduct has been taking place. Local authorities have traditionally taken the lead in the use of CPNs, and a private registered provider of social housing, charitable housing trust, or housing action trust that has been designated by a local authority in its area, and that can be found in Article 2 of the Antisocial Behaviour Authorised Persons Order 2015. That's the statutory instrument. So when and who can issue a CPN continued? CPNs are not immutable, and that can be found in the case of Stannard versus the Crown Prosecution Service 2019. The power to issue a CPN under section 43 of the 2014 Act allows an authorized person to vary or discharge a CPN as well as issue one. The affected person should submit a written reasoned case to the authorized person that the CPN was inappropriate. This decision over whether to amend is subject to the authorized person's discretion according to the general public law principles and potentially amenable to judicial review. A procedure should be established for considering representations. In Stannard, the High Court held that challenging the validity of a CPN issued under the 2014 Act should be brought by statutory appeal and not as a defense to a prosecution for the breach of a CPN. So who can a CPN be issued to? And this is found in sections 43, subsection 1 and 44 of the 2014 Act. An individual over the age of 16, and in Staffordshire Moorlands, DC versus Saunderton, the Court of Appeal held that a CPN cannot be issued against the parent of an individual committing ASB outside of their home or school. A body, including a business, in this case, the CPN would be issued to the most appropriate person, e.g. a shop owner or owner of the premises. A CPN can be handed directly to the individual or most appropriate person or posted. However, where the most appropriate person cannot be determined, the CPN can be posted on the premises, provided a reasonable level of inquiries have been undertaken to ascertain who the who is the owner. For example, checking who owns the property with the land registry. So the test for issuing a CPN, and that's found again in section 43 of the 2014 Act. An authorized person can issue a CPN if they are satisfied on reasonable grounds that the antisocial conduct is having a detrimental effect on the quality of life of those in the locality. The antisocial conduct is of a persistent or continuing nature, and the antisocial conduct is unreasonable. There is no restriction on the type of behavior a CPN can deal with. For example, it can deal with noise nuisance, rubbish in gardens, and littering. A CPN can be issued in respect of a failure to act, section 57, as well as a positive act by an individual. Content of a CPN. A CPN can impose prohibitions or requirements on individuals or organizations to either stop or do specific things, for example, to require a dog owner to attend training classes, take reasonable steps to achieve specified results within a specified time frame. The terms of the CPN must be necessary and proportionate. The duration of the CPN should be limited in time, and that can be found in Stannard. And CPNs are intended to deal with short-term or medium-term issues. Longer-term issues requiring more onerous restrictions and requirements. A court-issued order may be more appropriate. Notices should provide details of how to appeal. So prior to issuing a CPN, written warning must be served. The written warning must make clear that it is that if the antisocial behavior continues, a CPN could be issued. It should also outline the antisocial behavior complained of, outline the detrimental effect, and state when the behavior must have changed by, and therefore when a CPN is likely to be issued. A reasonable time should be given for compliance in each case, depending on the circumstances. So, for example, several weeks may be deemed reasonable in a case requiring waste to be removed, whereas in other cases, the issuer could require the behavior to stop from the date of the warning, and that could be something such as noise nuisance. The warning must also cover the consequences of a CPN being issued and breaching one, and contain the date of issue and the name and authority of the issuer. And penalties for failure to comply with a CPN. 3 main sanctions are available to the issuing body when a CPN is not complied with. These are fixed penalty notices, FPN, those are section 52, remedial work, intending to put the situation right, section 47, and prosecution, section 48. So taking each one of those in turn, fixed penalty notices. Where an individual has failed to comply with a CPN, an authorized person is able to issue a fixed penalty notice. The notice must be less than £100 and give the following information: details of the circumstances surrounding the offence, the period during which proceedings will not be taken for the offence. The notice should state that a person cannot be convicted if they pay the FPN within those 14 days. The amount of the FPN, the name and address of the person to whom payment must be made, and methods of payment. Prosecution. Where a person is prosecuted, they will be guilty of an offence and liable on summary conviction to a fine and or imprisonment for an individual, or a fine in the case of a body. A person will not have committed an offence if they took all reasonable steps to comply with the CPN, or there was some other reasonable excuse for their failure to comply with it. Once a person has been convicted of an offence under section 48, the court will also have the power to order forfeiture of any item used in the commission of the original offence, make a remedial order to ensure that the specified work set out in the original CPN requirements is either undertaken by the defendant or by the specified local authority, and that's section 49 of the Act. The Act allows for pre-conviction seizure. A court can order the seizure of any item by a constable or designated person used in the commission of the offence, provided a justice of the peace is satisfied on information on oath that an offence under section 48 has been committed and that an item used in the commission of the offence has been on the premises specified in the information. A warrant will be issued authorizing the constable or a designated person to enter the relevant premises within 14 days to seize the item, and reasonable force can be used if necessary. The item will be retained until any criminal proceedings under section 48 have been determined, provided that they were started within 28 days following the day the item was seized. Otherwise, the item must be returned within that period, and that can be found in section 51. Remedial work. Where a person has been issued with a CPN and failed to comply with it, the relevant local authority may take action under section 47 to have the work carried out to ensure the failure is remedied on land open to the air only. In this case, consent from the owner-occupier is not required. Issue a notice on premises other than land open to the air, so indoors. Specified the work to be carried out to remedy the failure, give the estimated cost of the work, inviting the defaulter to consent to the work being carried out. Where the defaulter has been issued with this notice, the authority may have the work carried out provided necessary consent has been given. That is, the defaulter or the owner of the premises has consented. However, where the defaulter cannot be located, the necessary consent requirement will not apply. And so the cost of remedial work, when carrying out works under section 47, a local authority should provide details of the work provided and the final sum payable by the defaulter. This sum should be no more than the cost incurred by the local authority in having the works done. That is, it should be a reasonable charge. The amount, this amount can be appealed if the defaulter feels that the sum is excessive. Following an appeal against the amount, a magistrate's court can confirm the amount or substitute a lower one if it deems it to be excessive, section 47(8). And reasonable charge also includes admin charges to the local authority. A person issued with a CPN has a right to appeal to the magistrate's court within 21 days of its date of issue. And there are several grounds. So the grounds for appeal are: the conduct complained of did not take place, it did not have a detrimental effect on the quality of life of the locality, was not of a persistent or continuing nature, was not unreasonable, or was conduct that the person could reasonably be expected to control or affect. The CPN or its requirements were unreasonable. There was a material defect or error in relation to the CPN. The CPN was issued to the wrong person, for example, in an organization or a business. And in relation to any remedial work undertaken by the local authority under sections 47 and 49, the cost of undertaking it were disproportionate. And so on appeal, the magistrate's court has the power to quash the CPN, modify it, and dismiss the appeal and uphold the CPN. An appeal is determined under the magistrate's court's civil jurisdiction. That's paragraph 43 of Stannard. And so now moving on to criminal behaviour orders. The provisions relating to the criminal behaviour order, relating to criminal behaviour orders are in part true of the of the 2014 Act, as I stated. CBOs is an order on conviction available following a conviction for any criminal offence in the Crown Court, Magistrates Court, or Youth Court. The order is aimed at tackling the most serious and persistent offenders where their behaviour has brought them before a criminal court. It can also be applied for in the event of a conditional discharge. It is, however, not available where an offender is given an absolute discharge. CBOs replace the antisocial behaviour order on conviction and the drink banning order also on conviction. Breach of a criminal behaviour order is a criminal offence, unlike breach of an injunction preventing nuisance and annoyance. Those injunctions preventing nuisance and annoyance are civil orders and applied for in the county court. So the conditions for making a CBO are as follows. When a criminal court can make a CBO against an offender following conviction if both of the following two conditions are met. The court is satisfied that the offender has engaged in behaviour that caused or was likely to cause harassment, alarm, or distress to any person. And this includes any antisocial behaviour relating to gang members. And then the court considers that making the order would help prevent the offender from engaging in behaviour likely to cause harassment, alarm, or distress to any person. The Director of Public Prosecutions versus Bulmer, 2015, gives clarity regarding the conditions for granting a CBO. And Section 331, subsection 1B of the Sentencing Act 2020, a court cannot make an order of its own initiative only on the application of the prosecution. It should be noted that in condition 1, previously in antisocial behaviour orders, it was likely to cause harassment, alarm, or distress to any person save for those in the same household. So that's been removed. So it's any person at all, including those in the same household. Who can apply for a CBO? So as I've said before, they can only be made against an offender on the application of the prosecution. Where a case is prosecuted by the Crown Prosecution Service, it is a matter for the CPS whether to apply for a CBO. But it is possible for a relevant local authority or police force to ask the CPS to apply for a CBO in a particular case. Where a case is prosecuted by a local authority or other prosecutor, the decision vests with that prosecutor. There is no power to entertain an application for a CBO by another defendant or an interested non-party, such as a local authority that is not the prosecutor. And so the application process, a court will consider the CBO application after conviction and subsequent sentencing for a criminal offence. Once made, the order takes effect as an ancillary order to sentence, and that's subsection 3 of section 331 of the Sentencing Act 2020. In the case of an offender under the age of 18, the prosecution must find out the views of the local youth offending team before applying for a criminal behaviour order. The CBO application procedure is governed by Part 31 of the Criminal Procedure Rules. The prosecutor must serve upon the defendant notice of its intention to apply for a CBO in the event of a conviction as soon as practicable and without waiting for the verdict. And you can use the form there, the Criminal Procedure Rules provides form CBO0020 for this purpose. And the notice must summarize the relevant facts, identify the relevant evidence, specify the proposed wording of the CBO, and attach any new evidence relevant to the application that has not already been served. Assuming that valid notice has been given, the Criminal Procedure Rule 31.3 subsection 4 provides that the defendant must respond in kind by serving any evidence upon which they intend to rely in resisting the application that has not already been served as soon as practicable without waiting for the verdict. Any party that wishes to rely on hearsay evidence must give notice of their intention to do so under Criminal Procedure Rule 31.6, and in order that the other party can consider whether to apply under Criminal Procedure Rule 31.7 to require the attendance of that witness for cross-examination. So the purpose of giving that hearsay notice is to put the other person on notice, and it's for them to make the decision as to whether they want to cross-examine that witness. So in terms of evidence, when deciding whether to make a CBO, a court is entitled to hear evidence led by both the prosecution and the offender. The statutory guidance states that although formal consultation requirements have been kept to a minimum, local authorities and police forces are likely to wish to consult with other relevant bodies, such as social services, schools, and housing providers, before asking the CPS to apply for a CBO or indeed applying for one themselves. Evidence that may not have been admissible in the original criminal proceedings in which the offender was convicted may be admissible as part of a CBO application, for example, hearsay evidence or bad character evidence. And so an adjourned CBO application hearing, where a CBO hearing has been adjourned and the offender fails to attend the subsequent hearing, a court will have the following options: adjourn the hearing for a second time, issue a warrant for the offender's arrest, hear the proceedings in the offender's absence, provided it is satisfied that the offender had adequate notice of the time and location of the proceedings and was previously informed of the possibility of the proceedings being heard if they failed to attend. Where an application for a CBO has been adjourned, the court may make an interim order if it thinks it is just to do so. And so dealing with prohibitions, a CBO can both prohibit an offender from doing something or require them to do something. So in terms of prohibitions, it could be a non-association prohibition, for example. And in terms of requirements, it should really go to the underlying reason for the CBO. So for example, if it's somebody who's addicted to drugs, it could be to access drug treatment or something like that. Any CBO should, as far as practicable, avoid any conflict with the respondent's education, work, or any other court order. In the case of SIMSEC 2015, this concerned a variation of a CBO to an ASBO with only the first prohibition. The second condition, which concerned a prohibition on possession of drugs paraphernalia, was not reinstated, as the prohibition was less specific and precise than that which was found to be unnecessary in the case of R versus Briggs. So it's really important that when drafting the prohibitions that they are precise and specific. As you know, breach of them is a criminal offence. It is possible that the prohibitions sought will interfere with one or more of the offender's ECHR rights. Interference with some rights is justifiable where it is necessary, prescribed by law and proportionate. So when drafting prohibitions, one must ensure that not only are they precise and specific, they must also be proportionate. A requirement in a CBO. So for example, somebody attending a particular course must have the following details: where attendance at a course is required, specify details of the course and what is involved, and also the frequency of the appointments and the issues that these should address. Be suitable and enforceable, specify who will be responsible for supervising compliance with it, an individual or an organization, for example, LAs or a recognized provider of substance misuse recovery. Specify the duties of the person responsible for supervising compliance in relation to it, promoting compliance by the offender with the terms of the CBO, and taking responsibility for informing the chief officer of police for that police area and the prosecution where the offender has complied with the requirement, or indeed has failed to comply with them. So the duration of a CBO. So the CBO itself must specify the duration. It may also specify the period that particular prohibitions or requirements will have effect. So it's not necessary that all the requirements or prohibitions have to last for the entire duration of the CBO. A CBO will take effect on the day it is made and will last for a fixed period of at least 2 years to an indefinite period. So the minimum period is 2 years, and I'm referring specifically to adult offenders, and to an indefinite period or until further order. If an offender is already subject to a CBO, then a new CBO can be made to take effect on the day the previous order ceases. For under 18s, a CBO will take effect on the day that it is made and will last for a period of between 1 to 3 years. And as I said, interim CBOs, a court may choose to make an interim CBO if it considers it is just to do so, for example, to protect victims or the community. So where there's a contested CBO hearing, but the sentence has taken place and the contested hearing is sometime in the future, the court can make an interim order to cover that period. Varying, discharging, or breaching a CBO. A court is able to vary or discharge a CBO on the application of an offender or the prosecutor. Varying a CBO may include adding another prohibition or requirement to extend its effect. Where an initial application to vary or discharge a CBO has been dismissed, no further application can be made without the consent of the court or the agreement of the prosecution or offender, depending on who made the initial application. Breach of a CBO, as I said, is a criminal offence. Therefore, an offender who, without reasonable excuse, breaches a CBO by either doing something they are prohibited from doing or failing to do something they are required to do, will be liable on summary conviction in the magistrate's court to imprisonment up to 6 months or a fine or both, on conviction on indictment in the Crown Court to imprisonment of up to 5 years or a fine or both. And then dealing with CBOs specifically to under 18s. Breach of a CBO involving under 18s will take place in the youth court with a maximum possible sentence of a 2-year detention and training order. Breach proceedings can be reported in the case of under 18s. There is a requirement to periodically review compliance with a CBO. This is where an offender will be under 18 at the end of a review period, and the CBO will last until the end of the review period and beyond. A review period is 12 months from the day on which the CBO took effect, or if varied, then the date on which it was most recently reviewed. Section 45 of the Youth Justice and Criminal Evidence Act 1999 applies in the case of breach proceedings, allowing a court to restrict publication of certain information in order to protect the identity of the child or young person. The decision to publicize a CBO imposed on someone under the age of 18, will be taken by the relevant local authority or police force, unless an order has been granted under Section 39 of the Children and Young Persons Act 1933, prohibiting the publication of certain information that could identify a child or young person. Thank you for your time. I will now hand over to Richard.
Thank you, everybody. I'll just load up the slides, and then we can make a start. Thank you. My name is Richard Davies. I'm a member of Chambers. First of all, thank you very much to Russell for the kind introduction, and to Kenniesha also for her slides. I'm going to be talking today on the subject of closure notices and closure orders. I've put my email there on the screen. If after this talk you want to email through with any questions, please feel free to do so. Also, I'll be relating various case authorities during the presentation. If you need a copy of any of the authorities in full, again, please feel free to email and I'll pass on those authorities to you. The purpose of today's talk is effectively threefold. We are going to be looking at a broad overview, first of all, regarding these two topics. I'll put in, secondly, a few reflections from my own experiences in court in relation to closure notices and closure orders. And finally, as has been mentioned earlier on by myself, there's a couple of case authorities where we look at particular issues that you may be interested in relating to this particular topic. So just to make a start then, as I say, those are the three issues that we're going to be looking at. And firstly, dealing with the legislation. You've got closure notices, which are governed by sections 76 to 79 of the Antisocial Behaviour, Crime and Policing Act. And then from the same legislation for closure orders, you're looking at sections 80 to 86. There is also statutory guidance to assist in relation to both the closure notices and closure orders. Let's start then with closure notices. What is a closure notice? Well, it's a legal document which prohibits access to a premises originally for 24 hours. This can be extended to 48 hours. However, where the notice is issued by a police officer of at least the rank of a superintendent, or in your guys' case, issued by a local authority and also signed off by a chief executive or the delegate of that particular role, the time period can be 48 hours. The statutory guidance, what does it say about it? Well, it describes closure notices and the subsequent closure order system as a fast, flexible power that can be used to protect victims and communities by quickly closing premises that are causing nuisance or disorder. And that is pretty self-explanatory. Obviously, these problems can develop over time, but equally they can develop quite quickly. Therefore, you have this power to get on top of the problem straight away and to try and deal with it for local residents. It's designed on purpose as a short-term fix. Therefore, it has limitations regarding what it can actually be used for. For example, that a closure notice cannot prohibit access to the premises by the person or people who actually live at the premises. That obviously makes a lot of sense because proportionality wise, you have to go through the process towards a closure order. But certainly with a closure notice, you can put somebody on notice in relation to a particular order that you'll seek subsequently. It can be issued only if reasonable efforts have been made to tell the person who lives at the premises about the actual closure notice. The issuer of the closure notice, i.e. the local authority in your guys' case, should also tell any person who has control of or indeed the responsibility or an interest regarding the property about the notice being issued. Again, that's simply common sense to make sure everybody who's involved in the property knows about the situation. Now, what must a closure notice do? Well, it's got to identify the premises to which the notice applies. And it's particularly important in some cases to be absolutely clear as to what part of the premises, if not the whole premises, that notice relates to. So there's no confusion. So for example, you can talk about the precise land it applies to within the closure notice, which precise buildings, outbuildings, those sorts of topics. It's absolutely clear. Also, the closure notice should explain the effect of the notice, and that should be set out in layman's terms. So it's easily understandable by the person who receives it, not necessarily in legal speak. Should also state that a failure to comply with the closure notice is an offence. And indeed, within that, you should be looking to highlight the appropriate penalties for breaching the notice. It should also state that an application will be made for a closure order to follow on from the closure notice. Of course, that application is going to be at court, so the details of the court, including the address, and indeed the timing of the hearing must be supplied. Again, a bit like explaining the closure notice, the notice itself should explain the effect of a closure order if one is granted, again, in layman's terms. And it should also, within the closure notice, provide information about names of people, organisations, for example, in the area that can help with housing and legal matters regarding the topic of closure notices and closure orders. And indeed, you may wish to include the contact details of some of the organisations to assist the recipient when they receive this closure notice. So, what is the standard for issuing a closure notice? Well, again, we've talked about how it can be done via the police or a local authority. But to do so, the local authority would have to be satisfied that on reasonable grounds that that particular premises and the use of it has resulted, or if no notice is issued, is likely to result in nuisance to members of the public, or, similar point, has occurred or is likely to occur if the notice is not issued, disorder near those premises associated with the use of the premises, and also that the notice is necessary to prevent that from continuing, occurring, or recurring. Of course, people would ask, well, what is the issue of necessary? How do we judge that? Well, it's a matter of judgment in individual particular circumstances. And indeed, when we work through this process, we'll have a little bit more of a look at the different factors that can weigh up in an individual's judgment when they make this determination on closure notices and subsequently closure orders. So, moving on then to the topic of closure orders, you've got your notice issued. What happens then? Well, if it is the case that once a notice is issued, that for whatever reason, even in the short time frame, whoever's issued the notice becomes concerned regarding the point about whether it can be cancelled, of course, a cancellation notice can be issued. However, of course, the vast majority of the time, if you've decided to issue a closure notice, you're then going to be moving on to the closure order procedure. When regarding closure orders, the court should be notified to make sure that there is an adequate listing in place. And if the local authority know that they wish to issue a closure notice, particularly given the time frame, the tight time frame, and the pressure also on court listings, it would be beneficial, of course, to give the court as much notice that you are going to be seeking this listing in relation to the closure order, particularly bearing in mind what we've already spoken about with the closure notice, needing that accurate information for the party or parties receiving the closure notice. So, once the matter is listed, what happens? Well, what is often common with closure order hearings right at the start is that the advocate can be there, representative of the local authority, a representative of the police, but the respondent may not attend. They may indeed be absent. In the circumstances, through the very nature of the closure order procedure, you may wish to proceed in their absence. And this is ultimately a factual determination for the tribunal. But the crucial point is that has that individual voluntarily decided not to attend? Okay, have they been made aware of this closure notice and the subsequent application, but for whatever reason, they've decided not to attend? Well, how can we make a judgment on that? Because it is very much a factual determination for the magistrates or district judge. And some important factors are as follows. Whether actual contact has been made with the respondent, because obviously if somebody from local authorities managed to speak to them, and for example, the response being quite aggressive back, ignorant of the procedure, that's good evidence that they voluntarily decided not to attend. Equally, making very, very clear that the closure notice must be displayed in a place of prominence where the recipient, if they're not in at the time that it's delivered, will be aware likely of the notice. So, for example, on the actual front door of the property, if it's just one property that you're looking to apply it to, or indeed on a communal entrance to a block of flats, if you're trying to apply it to a block of flats. In the situation where it's several properties, my argument would be from court that the more notices, the more prominence of the positions, the better. Equally, any communications, any leads that you have, any phone numbers, any email addresses, doing everything you possibly can to provide information. Noting if there are any particular health or language difficulties regarding the respondent, but for example, if you know that there isn't, then you can make those points clear to the court as well. Also, any further reports of bad conduct in relation to notice. Very straightforward example that I did a number of months ago. Police officer attended court, respondent didn't, but there had been reports to the police that since the notice had been displayed, there'd been neighbours who'd actually seen the respondent just go to their front door, rip down the notice and throw it to the floor, effectively. That obviously is good evidence that they're not going to attend this particular procedure. So if they're not there, make that application using those particular factors. If they are there, of course, though, you can still proceed. And what is the legal test for a closure order? Well, the court may make a closure order if it's satisfied that a person has engaged, or indeed if the order is not made, is likely to engage in disorderly, offensive or criminal behaviour, or that the premises has resulted or is likely, if the order is not made, to result in serious nuisance to members of the public. And then finally, exactly the same clauses, but in relation to disorder near the premises. Often with these cases, the behaviour can tick all three boxes, but crucially with those three, you've only got to be able to show one. It may be useful when you're getting a signed closure order just to simply ask the magistrates to know if they found that the order is necessary under all of those three headings or just one, particularly when bearing in mind if you want to apply for an extension in due course. But once one of those points is found, the other condition to bear in mind is that the order's got to be necessary to prevent the behaviour, the nuisance, or the disorder from continuing, reoccurring, or occurring. And the standard of proof is a civil standard. It's a balance of probabilities. Obviously, the more evidence you have, the better, but particularly if you can show from a variety of residents, a variety of aggressive, criminal, disorderly, nuisance type behaviour, the more evidence you can show, the better the chances that you've got on that civil balance of probabilities. Just moving forward to the next topic on closure orders, which is housing. And this is obviously particularly important because one of the points that is often raised in response to a closure order application is that particular individual's Article 8 rights, the right to the family life and indeed possession of their property. And that is obviously important because, as we'll come on to later, you can look at a closure order being partial or a full closure order. And if you're looking at a full closure order, of course, it's got the power to remove that person from living at that particular property. Now, it's very important to say that in terms of a closure order, there is no duty to guarantee alternative housing. But of course, as part of the balancing exercise, it's important to look regarding considerations regarding housing for whoever is the person potentially receiving the closure order. And some factors that are particularly important is that, yes, we don't want to reward bad behaviour, but equally, there must be concern about making people homeless. So, of course, part of a closure order application might be the question of what other mechanisms have been looked at for homes for these particular people. Has alternative accommodation been provided? What's been the attitude towards that alternative accommodation? Those sorts of things. Does that person have any particular vulnerabilities? Crucially, are any children involved? This is a big concern regarding magistrates. It's a question that I've often had from them regarding, do children live at that particular address, for obvious reasons, because there's extensive duties regarding children and homelessness. As I mentioned earlier, the respondent's response regarding attempts to engage with alternative housing, if they've had a positive response, then all well and good. But equally, if the local authority's done everything it can to try and find alternative accommodation, and for whatever reason the respondent has continually ignored this or not engaged with it, that's an important factor to look at. And indeed, mention regarding housing is regarding anything else that's happening with the property. That might mean the person has to leave it, for example, a possession claim. Alternatives, another important factor that comes up from magistrates regarding closure orders. Do we have to do this? Have other mechanisms been looked at? Now, of course, again, a bit like the housing situation, it's not the case that the court has to look at things and say, well, you've got to go through a whole tick list of other things first. But it is useful good practice to look at the individual circumstances and to try and explain to magistrates why other forms of alternatives to closure orders haven't taken place. So, for example, community protection warnings and notices, behaviour contracts, or indeed mental health support. Obviously, a lot of the people we're dealing with in these situations have their own vulnerabilities. Could the behaviour that is seen by neighbours as being aggressive and a nuisance, is it actually something to do with a mental health condition? Particularly important to look at. Brings us on to the next issue. When you're making this application, you do have that particular choice to go for a full closure order, which is barring anybody from the property, making certain exemptions, for example, the emergency services. Or do you want to look at a partial closure order, where that particular tenant is allowed to remain, with perhaps again certain exceptions made, but banning all other visitors? And factors to bear in mind when you make that determination is, what is the actual source of the problem? Could it be that it's simply that one individual, for example, being aggressive towards their neighbours, constantly playing loud music, banging on the walls, that sort of thing? Or is it other people going to the property and causing problems and maybe even exploiting that individual? And that links to what is the nature of the problem. And the good example is, of course, drugs. The cuckooing of people's property, the exploitation through drug dealers and other drug users coming to that particular property. If you've got somebody who's very vulnerable and is a drug user, then a good example would be that sort of case to maybe consider, is a partial closure order a better route to go down to ban other people rather than a full closure order? Might a full closure order do more harm than good? And again, that's linked to the final point there of the culpability of the offender. What I said right at the start there. When you look at a problem, can you fairly say this behaviour is 100% the fault of that particular person? Or indeed, are they being exploited? Are we going to do a better job by simply removing the other people from the premises rather than potentially doing a full closure order which targets that particular person? So that's a little bit on the background as to what you're actually asking for. And now we're just going to do a little bit on the procedure regarding closure orders, because of course everybody has the right to a fair hearing, particularly when they might be potentially losing their housing. The first hearing regarding a closure order must be heard within 48 hours, but it might not well be effective. Often you'll get people turning up in a bit of a panic, a bit stressed. They haven't had time to get legal representation nor legal advice. So in those circumstances, fairness dictates that it might be possible to adjourn that particular hearing. Crucially, you must bear in mind the idea of serving evidence by way of the hearsay route, for example. The very nature of these orders means that people might not be keen to come down and say that the neighbour is causing them problems in an open courtroom, even with special measures. You'll well know that often statements are provided with residents saying, I'll give you a statement, but I ain't going to court for this. Or you've got a circumstance even where they provide the statement, but it's done anonymously. Normally, hearsay evidence in civil procedures does have that requirement for the 21-day notice. But of course, in these procedures, that just isn't practical. So one of the important steps to take at the first hearing is to make sure that any hearsay evidence you are intending to serve, if you haven't served it already, reducing that period of notice regarding the hearsay. So what happens if somebody turns up, says, I don't have a lawyer, I need more time, etc., etc.? Well, as has been stated, they can ask for that hearing to be adjourned. What can then happen is that you can ask for the closure notice to remain in force, until that final hearing. Remember what I said about closure notices, that you can't, technically with a closure notice, remove the actual tenant. But of course, the very nature of the closure notice means that you've got a bit of temporary protection, at least regarding the problem. When you come back for the final hearing, if the closure order is made, it must be no longer than 3 months. And indeed, as we spoke about, it can have various restrictions regarding the persons who are allowed in there, the timing that they're allowed in there, and indeed the circumstances. And indeed, it can apply usually to the whole of the premises, but sometimes only to part of it. Once your 3 months is coming towards an end, if you want to maintain the closure order, you can apply to extend it. And there's a very similar test that's put in place, as you can see on the screen, to dictate that for a closure order extension, is it necessary to prevent that occurrence, reoccurrence, or continuance of the disorderly or criminal behaviour, the serious nuisance, or the disorder near the premises. And also, very important, that the court's got to be satisfied that the other party that could apply for that extension, so for example, when you're applying as local authority, the police, and vice versa, you've got a circumstance whereby you've got to consult with the other party. I don't think from my experience I've ever seen a situation where the local authority are saying that they want the order to continue, but the police are saying no. It's very much in tandem because obviously you're trying to deal with the same problems. Hearing is needed for the determination of an extension. Can't just be nodded through over emails or via letters. When can it be made? Well, it's got to be made, the application, any time up to the order is due to expire. And we've already talked about the period of 3 months. So very much keeping these matters under review, knowing that an order is coming to an end soon, and then making that application. And often the question's asked, well, if we, for example, want to keep an order going, but for whatever reason the tenant's been removed, how are we going to prove that particular point about why we need this order to continue? And there's some particular points that I've put on the screen there that can be borne in mind. One of the best techniques I find when presenting these matters is to get supplementary statements from the local residents, the people who provided you the initial statements, just to say how much the quality of life they have has improved since the closure order has been put in place. And of course, you can refer to the previous statement at that example to show that this is what they were saying originally, this is what they're saying now. Similar point regarding the police. Obviously, the police can provide a statement regarding the initial closure order. They can provide a supplementary statement to say how this closure order has assisted and how it's likely to assist into the future. And of course, by the very nature of closure orders, it's very likely that a respondent will have moved on, particularly obviously if it's a full closure order. So when you're looking at an extension, that point that we looked at with the initial closure order about the person's human rights, right to housing, that often becomes less of a factor if they've moved on under the circumstances. Couple of points, technical points, just in relation to if a closure order is made. Of course, the individual has a right to appeal. That is an appeal that's by way of a full rehearing. They don't have to specify any grounds of the appeal. Appeal notice has got to be issued within 21 days. Obviously, with the pressure of court listings, that doesn't mean it has to be heard within 21 days. But the very nature of your closure order with your 3 months, obviously, the court is going to be wanting to hear it soon before the closure order expires. Also, the point regarding the discharging of a closure order, Magistrates Court may not make an order discharging the closure order unless satisfied, and then you've got the conditions there, very similar to the conditions for an order being made in the first place. Just a little bit more on the background, that an authorised person may enter premises in respect of which a closure order is enforced and do everything necessary to secure the premises against entry. Also, a person may be authorised for this purpose in the case of a closure order made on an application or from police or from a local authority, and that a person may use reasonable force to achieve that. Equally, a person who without reasonable excuse remains on a premises that's been subject to a closure notice is committing an offence. There is a defence of reasonable excuse. However, I've put a little bit of information there regarding the particular offences and the punishments for individuals who breach a closure notice or who breach a closure order. Of this point, just regarding the exceptions, we're looking at circumstances here like 999 999 emergency services, contractors that you may require to go to the premises if you're managing it as a local authority, and anybody else who may have a reasonable reason for being there in the circumstances. So I'm going to move on now and just talk in this final section a little bit regarding case law and particular issues. And as I say, if you need a full copy of these authorities, please feel free to drop me an email. This case of Leary is an interesting one. It's some years now, obviously, in age, but in that example, there was a full closure order made for property in relation to Class A drugs. And the appellant appealed on the basis that less draconian measures, such as a partial closure order, should have been considered before a full closure order was made. What was actually a factor within that decision is that the Magistrates' Court noted that the appellant was unlikely to engage in any other forms of support that the local authority and police would offer. And again, remember we said earlier on that that might be a factor that you look at regarding if you go for a partial order or a full order. Very similar to what we've seen earlier, that the respondent in that particular case argued that Article 8 was a qualified right. And of course, you've got to balance it with neighbours within the area. They've got Article 8 rights as well. They've got Article 8 rights to the peaceful enjoyment of their home. So it's got to be a balancing act. It's not simply a pure right for that individual who receives the order to say, well, this is my property. I've got a right to do whatever I want in it. So what happened in that particular case? Well, the court ruled that alternative methods instead of a closure order, they might be looked at as a matter of good guidance. So going right the way through, looking at those other examples that we've looked at earlier, all the other things we can think of, injunctions, prosecutions for specific criminal offences, community protection notices, mental health support, behaviour contracts, all of those sorts of things, yes, they should be covered as a matter of good guidance, but it's not a legal requirement to do so. In addition, there's no power to force an applicant for a closure order to consider a partial closure order over a full closure order. So you haven't got to justify to a court. There's no test saying that you've got to show them why a partial closure order can not be applicable in a certain case. But as a matter of good guidance, you don't necessarily, as I say, need to go through every single one of the examples that I've given, but just a broad flavour within the statement from the officer of the local authority that's underlining the application. Just a brief mention of alternatives that you've looked at. That's going to be very helpful for good guidance. And I think that when I've presented these matters, that particular factor has been very persuasive with magistrates. Because if they can see that you genuinely look for other ways of dealing with this problem and they haven't worked for whatever reason, they're going to be more supportive of your application. Another case here, again, quite an old one, but particularly important. This is a case of Brine. And this is where the closure notice was actually challenged in the case. And this has been that the police on that occasion, it was said, had not had appropriate regard to the appropriate Home Office guidance before their closure notice was issued. The appellant states that that must be a relevant concern because the possible knock-on potential criminal effects of a closure notice should it be breached. So somebody's saying here effectively that if you're going to put me on one of these notices and I'm going to potentially commit a criminal offence, then all good guidance has got to be followed before you can level the appellant as an individual that they may be in a situation where they could commit a criminal offence. And what the appeal court said here, and this was a police case, but it's equally applicable to local authorities, is that they drew a distinction between situations whereby if it's ever shown that there's arguments for manipulation or bad faith for issuing a closure notice, that is very, very different to a situation where the local authority or the police have simply looked at a factual circumstance and made a determination to go for a closure order. or it's indeed, sorry, a closure notice. Bad faith manipulation, that is obviously going to be very, very difficult for anybody who's the appellant in these cases by way of opposing the closure notice to prove. Just covering from your guys' perspective for local authorities, again, bit like the previous case, it's just about covering all of your bases and explaining why on the facts of a case you've decided to go for a closure notice. Judgment also dealt with the question of the time window to challenge a closure notice and said that if it's not through the criminal courts, then it is very limited. So that being the idea that if you get the closure notice, obviously you can go and challenge the closure order, but equally, if you want to actually say, well, actually, I don't want to go that far, I just want to say that the closure notice is not valid for whatever reason, or make arguments against that, yes, of course, the time limit is limited for that. But what's the reason for it? Well, it's the whole underlying system, isn't it, of the closure notice and closure order system. It's there for local authorities to deal quickly with a problem. And equally, from the local authorities' perspective, it's deliberately designed like that because you don't want to be bogged down in debates regarding the actual closure notice itself when you want to get on and issue the closure order. And indeed, the court did recognise that any issues regarding the validity of the closure notice, any legal proceedings, that could be used as a stalling tactic by the other side. It is equally the case that the court confirmed that the Article 8 point, that cannot be raised as a ground to challenge a closure notice. Now, bear in mind what we said earlier, distinction, closure notice, you can't remove the tenant under that. You can stop other people, but you can't remove the tenant. That's the point regarding Article 8. You can, of course, in a closure order if you wish to apply for that. And this logically follows on the point regarding from the case of Leary, that namely, it's of limited use regarding the context of closure orders, that then it cannot be more important in the context of closure notices. So again, you see the distinction between the fact that you've got more powers under a closure order than you do a closure notice. Just another case here, the one of Turner, again, quite an old case, but very important. In this case, the respondent to the notice brought the appeal proceedings on the basis that a closure order application could not be adjourned beyond 14 days. Now, this is obviously a situation, bearing in mind what we said earlier, that you go to court, the other party isn't necessarily ready, they want an adjournment. What happens regarding the 14 days? Well, in this particular example, there had been actually several adjournments of the proceedings within that 14-day window. And there were a couple of issues that came up. One was the lack of legal representation for the individual. And then there was also a further adjournment on the basis that when the individual did get solicitors, they claimed, have enough time to consider the case papers and take proper instructions for a contested closure order application. In that authority, the appeal court examined the rationale for the 14-day rule. And obviously, there were concerns about having that 14 days as effectively a balancing act, giving those people who want more time to get legal representation the opportunity to do so over those 2 weeks, but equally at the same time, bearing in mind the whole point of the closure order system to try and deal with problems quickly. So they talked about the various arguments on both sides for the 14-day rule. And they concluded that in certain circumstances that it was lawful to adjourn the effective closure order hearing beyond the 14 days. And in that particular example, it was noted that it was the other side responding to the closure order application who were responsible for the 14-day delay. It wasn't, for example, the local authority. And there's a little bit there of section 54 of the Magistrates Court Act talking about adjournments in general, and very much going back to what I covered already, that obviously the interests of justice are sacrosanct in these matters, and you've just got to deal with that debate between dealing with these issues quickly, but giving people the adequate amount of time to try and get legal representation together and to challenge it, as is their right, if they say for whatever reason that the grounds for the application are faulty. Crucially, regarding going outside that 14-day window, there are exceptions as the case allows for, and they're not just limited to circumstances where there are exceptional circumstances. Obviously, though, if you're going beyond the 14-day rule, it's within everybody's interest to try and get it done as soon as possible, or indeed as close to possible as the 14 days as you can. This is just another final authority here, R versus Smith. Very straightforward point that's taken from this authority. I haven't gone into too much detail here because it often comes up the issues regarding extensions. What do we have to do to justify an extension? And this is a very useful authority because it actually puts into law the idea of the common sense approach. And what the common sense approach says is that if an order is not extended, and you've got proof to show why the order was justified of being made in the first place. And remember what I said, when the closure order is made, if the magistrates are finding it on all three of those boxes, make sure that those are all ticked on the closure order, because then when you come to an extension, you can say, well, look, we only have to show one of these three. The magistrates found that all three were in existence at the time. So that common sense approach, this authority, default position is effectively saying that if you don't extend the order, you've got a chance that this behaviour will recur. Very, very useful authority there regarding extensions. Okay, folks, that's it. Thanks very much for your time. As I say, my email is on the start of the slides. Let me know if you need anything. Just going to come off the presentation now because I think we may have a Q&A session. Thanks again for your time, folks. It's most appreciated. Cheers.
So in terms of questions, there's one: can you prosecute on a Environmental Protection Act, Section 80, breach on noise abatement notice, and also proceed with a CPN? I would say no. I would go along with the breach proceedings under the EPA. I think that would be overcharging if you were to also proceed with a community protection notice. And second question, there's a persistent unlicensed street trader, and despite numerous convictions, it has not stopped. Would you go for a CPN or a CBO? I'm of the opinion that a CBO would be more useful in such a circumstance. Obviously, the CBO is dependent on criminal proceedings currently in place, and a prosecution being founded and sentenced, and then you can apply for the CBO. If there are no current proceedings, then I would go down the CPN route. If, for example, there is a current criminal proceedings in place, and then I would serve an application for a CBO, which has more bite, power of arrest, and also a possible imprisonment. Thank you.
Right. Well, there doesn't seem to be any more questions, which indicates to me that you have been very thorough, both of you, in your presentations. So I'd like to just end this webinar and thanks so much to Kenniesha and Richard for their excellent presentations. And we hope that this webinar has been of value to you. Do take a few seconds, please, to complete and submit the feedback form, which should pop up when you exit this webinar. And just to reconfirm, the webinar and the presentations will be made available in due course, so you can watch this again if you so wish to. So thank you for joining Drystone Chambers. We have other webinars coming up, so follow us on Twitter and keep an eye on our insights page on our website, and we hope to see many of you again. So I'd like to thank our speakers, and I'm about to close this webinar, and we are most grateful to everybody for your time this afternoon.
Russell, I was just going to say, I think there's one final question just in relation
Oh,
to.
more
No,
questions
no, not
have
at
come
all,
in.
not at all.
Yeah, I can see that. Carry on,
to-
Richard, carry on.
Thank you. Thanks, Russell. There's a question come in. It's in relation to closure orders and closure notices, and it's talking about the rare circumstances where the final hearing for the closure order goes beyond the 14 days for whatever reason. And the person's asked, can the closure notice be extended until the final closure order hearing? My understanding in those positions is that it can, for the very simple reason that, like a closure order hearing that can't happen for whatever reason on the first day it comes to court, by continuing the closure notice, you've got the best of both worlds at the time for both sides as best they can in the circumstances, by, as I say, under a closure notice, allowing that individual to remain there, but providing the local authority and other residents who have been disturbed by the behaviour a degree of protection. So for that particular question, thank you for the question. As I say, that's my understanding of that particular position. I think also the questioner had another question there, Russell.
Yeah.
Is it possible to claim legal costs? My understanding, correct me if I'm wrong on that question, is the local authority making an application for costs. As I say, if I'm wrong about that, please just type another question. I personally have never seen a claim for costs for a closure order hearing. It is a civil procedure. It's obviously a different basis for costs than a criminal procedure. Generally speaking, and it's going a little bit off topic now, but generally speaking, for the civil applications in the magistrates' court, it's harder to get costs for any sort of civil procedure than it would be for a criminal one. So that may be the reason why local authorities, knowing the high standard for costs in civil procedures, don't claim the costs. I certainly have never been asked to claim costs for closure order, and it's never been something that a local authority has mentioned to me. I have occasionally said in the past, just as an abundance of caution, do you want to make a claim for costs, knowing that there's that quite a high threshold, and local authorities simply haven't taken the point up, probably because it would obviously invest time to put together the cost request, knowing full well that it's unlikely that you're going to get them. So I hope that answers that final question. Please let me know if there's anything further. Cheers.
Okay, thank you. Well, no other questions have come in. I think we're going to wrap it up now. Thank you both. Thank you to all quite a lot of attendees. So we hope to see as many of you again the next time we do this. We've got one coming up in a couple of weeks, I believe. So thank you very much, and have a good weekend all. Bye-bye.
Cheers, guys. Thank you very much. Take care.